And so I want to talk a little bit about how risk assessment can lead to the perpetuation of the overrepresentation of Indigenous persons, and how by not abolishing the system and continuing to do research without thinking about culturally specific responses to youth justice or adult justice system can result in overrepresentation. So this particular case is relevant to Indigenous persons, but the underlying decisions or the underlying result of this case has implications much further than just Indigenous communities. It has implications for all persons who might be underrepresented in traditional Canadian research. So that could be Black persons, it could be persons from a Southeast Asian origin, it could be persons from China, it could be persons from India. It really doesn't matter. It's the idea that because these persons make up a small proportion of all individuals that are typically included in research, the research findings might not generalize to these particular ethnic or cultural groups. And so in the case of Ewart, originally it was R versus Ewart. Ewart was found guilty of several very serious offenses, including murder, attempted murder, and sexual assault. So again, it's one of these cases where it's hard to kind of begin to maybe feel so much sympathy for the perpetrator of the offense, but the case decision goes much, much further beyond this particular offense. So the Ewart versus Canada case is where Ewart essentially sued the federal government, specifically the Correctional Service of Canada, and alleged that psychological risk assessment tools were not culturally appropriate for use with Indigenous persons. Essentially, there are a lot of different risk assessment tools used in Canadian correctional systems. In the youth justice system, for example, the Structured Assessment of Violence, Risk in Youth, aka the SAVRI, is a really commonly used tool. The Psychopathy Checklist Youth version is another assessment tool that's often used. In the adult system, the Psychopathy Checklist Revised is really commonly used to sort of inform broader risk assessment. The PCL family, they're not a risk assessment tool per se, but the assessment of psychopathy makes up a large part of risk assessment. So tools like the Historical Clinical Risk 20, aka the HCR 20, relies on the assessment of psychopathy. The Violence Risk Assessment Guide, also routinely used, relies on the assessment of psychopathy. And what Ewart was arguing is that the PCLR, and then specifically actuarial risk assessment tools, are not culturally sensitive. So for example, there are measures like the Static 99, that's a tool designed specifically for persons involved in sex offenses. Another tool, the Violence Risk Assessment Guide that I mentioned, it's another static risk assessment tool, which means that the assessor has to consider only the items that are included in that risk assessment tool in making their decision, or basically communicating a person's level of risk. So if I'm the risk assessor and I'm using the Violence Risk Assessment Guide, I cannot look at factors outside of the VRAG in communicating to the court what a person's level of risk actually is. And in the Ewart versus Canada case, what his legal team argued was that tools like the VRAG were developed using samples of primarily white male persons in conflict with the law. And because of that, it might not be clear whether these tools are culturally sensitive to Indigenous persons or Black persons or persons from Southeast Asia. And so basically, there's nothing that the assessor can do to consider cultural distinctions, because they are not allowed to deviate from what's included in that risk assessment tool in the first place. And risk assessment tools are really, really important to Canada's justice system. They're used at various stages. They can be used not just for sentencing decisions, but to decide the security rating of persons, whether that person is going to be allowed on a escorted temporary absence from prison, whether the person will be allowed or granted parole. And the court found that Ewart's scores were used in a report prepared for his parole that essentially labeled him as an undue risk to society. My personal opinion is that he probably was an undue risk to society, but we can't just think about Ewart in this case. we have to think about how these tools are being used every single day for effectively every single person in our justice system. And so there might be particular harms to certain persons who might actually be a lower risk, and we're failing to recognize that lower risk because the tool is not culturally sensitive to that particular person's background. So back in 2015, the federal court that oversaw the Ewart versus Canada case basically allowed the action against Correctional Services of Canada and deemed that it violated or constituted an unjustified violation of the plaintiff's, that's Ewart's, Section 7 right to life, liberty, and security of the person, so what's enshrined in the Charter of Rights and Freedoms. And that unjustified point is very key because it's basically suggesting that this violation couldn't be saved by Section 1 of the Charter, which I'm sure you'll all get to learn more about in like CRIM210, 330, classes like that. And someone who was really instrumental in allowing the federal court to reach this decision is Dr. Stephen Hart. I think I've talked about him in this class before when we were talking about the assessment of features of psychopathy. Steve is a faculty member in the psychology department, and he testified basically that these tools, these actuarial risk assessment tools, are susceptible to cross-cultural bias or variance, meaning that the reliability and the validity of an assessment tool might vary depending on a person's cultural background. The federal court decision in 2015 was appealed and then went to the Supreme Court of Canada, who basically upheld the decision and suggested that continuing to rely on those tools without ensuring that they're valid to Indigenous persons is a breach of Correctional Services of Canada's obligation to take all reasonable steps to ensure that information about a person is as accurate as possible. It's going back to the idea of evidence-based practices. So ultimately, it also noted that this didn't really infringe on Ewart's rights under Section 7 or Section 15 of the Charter, but it was going to require Correctional Service of Canada to remedy the issue of potential problems with cultural bias in their assessment of risk. And so the Supreme Court of Canada ruled that Correctional Service of Canada must ensure that its policy and programs are appropriate for Indigenous persons and are responsive to their needs and circumstances, as well as circumstances and needs that might differ from a non-Indigenous population. And so the Supreme Court of Canada left it up to Correctional Service of Canada to ensure that they take the necessary steps to update their research. During the Supreme Court of Canada decision-making, there was a release from the Commissioner of Correctional Service of Canada, basically saying that they're already doing all the things that the Supreme Court of Canada has required of them, even before Supreme Court of Canada made that decision. For Correctional Service of Canada to proceed, they need to either identify that the impugned tools are indeed appropriate for use with Indigenous persons, that they're not subject to cross-cultural variance, or if they are, develop other tools or change their assessment practices so that this issue of cross-cultural variance will no longer be an issue, and we would no longer, for example, at least in theory, see these systemic differences in justice system decisions across different cultural or ethnic groups.